Hi, my name is Oliver. Welcome to Crash Course. Today we're going to be talking about abortion. Abortion is a current hot topic due to Alabama banning abortion no matter the circumstance. But before we take a position, we must look at the history of abortion. Before the landmark case was passed, abortion was highly restricted and fought against. Regulations starting in 1821, Connecticut, protected women from poison in the abortion process. This leniency towards abortions continued in 1856. First trimester abortions were very widely legal or at least only misdemeanors. Nativism and a want for reform and conservatism later on caused a shift away from this. Post-Civil War groups such as the American Medical Association began advocating for regulation. This resulted in the 1873 Comstock Act, making access to contraception and information on abortions illegal to dispense. The complete ban was relieved in 1890 when abortions became allowed in cases of necessity for saving the mother's life. After a while, abortions became less taboo around the world, and in Europe, new, safer abortion methods, such as vacuum abortions, were becoming widely popular. By 1963, the Society for Human Abortion began advocating women's right to choose and challenged existing laws, such as how, by 1967, 49 states had abortion outlawed. The Supreme Court case Griswold v. Connecticut was a stepping stone towards the reform groups wanted, concluding that the right to privacy gave couples the right to use contraception. This pushback led to New York and Hawaii repealing criminal abortion laws in 1970 and more states following with the special circumstance allowance and the repeal of the Comstock Act in 71. In 1970, a single woman named Norma McCorvey was denied abortion access several times in Texas. Texas was one of the many states that banned abortions unless the mother was in direct danger of giving birth. McCorvey was obviously against this restriction and went against District Attorney Henry Wade. This case went through the district court, and the court ruled the ban to be unconstitutional since it violated a woman's right to privacy. It eventually made it all the way up to the Supreme Court. Since it was a time of activism and counterculture in the 1970s, many young women were for what Norma McCorvey was asking for. Various rallies and activists alike were already pushing for the right to abortion. So when the court case came to the Supreme Court, there was an array of support for Roe and a woman's right to choose what they do with their child. The lawyer that represented Roe was Sarah Weddington. She was the youngest person to win a Supreme Court case. She used various amendments to back her argument of it being a woman's right and liberty to receive an abortion, while there is no distinct amendment that gives the right to privacy. Many, like the third and fourth, allude to that right. The court recognized these rights from the previous case, Griswold v. Connecticut, which was used as heavy evidence in support for Weddington's argument. The Burger Court in 1973 eventually came to a 7-2 decision, with White and Rehnquist being the only to go against the choice. 4 years after Roe was passed, Congress passed the Hyde Amendment. This was passed in an effort to restrict abortion access and banned the use of federal funds to pay for abortions. The amendment states, in general, no funds authorized or appropriated by federal law, and none of the funds in any trust fund to which funds are authorized or appropriated by federal law shall be expended for any abortion. Later exceptions were made in cases of incest or rape, but in general, it represented how the government continued to be against abortions. In 1986, the case Webster v. Reproductive Health Services was tried. It imposed that public services couldn't be used for abortions because life begins at conception and unborn children have protectable interests in life, health, and well-being. It was very similar to the Hyde Amendment, but the life argument was not what it passed. As the court stated, the statement means only that a state could not justify any abortion regulation otherwise invalid under Roe v. Wade on the ground that it embodied the state's view about when life begins. It upheld Roe's protections but allowed states to make their own decisions about public funding. The radical feminist movement, the Sister Serpents, were formed after this case. They were very controversial due to them continuously asserting that women were superior to fetuses. 1992, Planned Parenthood vs. Casey was tried. Pennsylvania attempted to create a law to require women to notify husbands about their abortions. This directly violating their privacy led to the undue burden ruling regarding abortion laws. The new standard stated to protect the central right recognized by Roe, while at the same time accommodating the state's profound interests in potential life. The undue burden standard should be employed. An undue burden exists, and therefore a provision of law is invalid if its purpose or effect is to place substantial obstacles in the path of a woman seeking an abortion before the fetus attains viability. Violence towards those performing abortions also became a more prevalent act. There were multiple shootings and murders of doctors at clinics. In 1994, Paul Hill killed an abortion provider, John Britton, who repeatedly traveled to Florida to perform abortions. And in 2015, a shooting at a Planned Parenthood clinic killed 3 people. While it is majorly hypocritical to commit murder to advocate against what they perceive as it, Hill stated, "If we can use force to defend our children, why shouldn't we do so for our unborn children?" It's a little thing to think about. While Roe v. Wade was a landmark case, it led to unfortunate reactions by extremists. More controversy arose after Norma McCorvey took a pro-life stance years after she was part of the case. McCorvey began to assert that she was manipulated by prosecutors and that Roe v. Wade was destroying women, calling it the biggest mistake of her life. McCorvey ended up thankful that she was denied abortion at the time because she ended up living a happy life with a child. She also became closer to God over time and garnered a heavy conscience. McCorvey's opinion was informed by her own experiences with her child in the court system and her newfound religion, which is the most popular reason why people are pro-life. In 2016, Texas proposed provisions to restrict abortion providers by saying that they had to work at a hospital within 30 miles of a clinic. These provisions were struck down by the Supreme Court due to the undue burden ruling that Planned Parenthood vs. Casey decided to defend Roe v. Wade. Judge Ruth Bader Ginsburg asserted, "When a state severely limits access to safe and legal procedures, women in desperate circumstances may resort to rogue practitioners at great risk to their health and safety." Now in 2019, we are amidst a tense debate regarding extremely restrictive bills in states like Alabama. The recent Alabama abortion law criminalizes abortions as a felony offense based on the fact that the state law defines a person for homicide purposes to include an unborn child in utero at any stage of development, regardless of viability. Reasoning included in the bill consists of references to genocides like the Holocaust, equating pro-lifers to the abolition movement, and the assertion that Roe v. Wade has endangered legislation due to a lack of definition of when abortion should be legal. In the end, restricting safe legal abortions doesn't end abortion in general. It actually leads to more unsafe practices that kill women. From 2010 to 2014, 25 million abortions were unsafe out of 56 million, which is 46%. In addition to this, abortion rates are similar in countries where abortion is restricted and where it isn't broadly legal. Comparison is 37 per 1,000 in prohibited countries and 34 per 1,000 less restrictive countries, so appealing Roe v. Wade and imposing bills like Alabama's won't actually save babies. It will lead to the death of more mothers.